Did the state of Indiana use false testimony to obtain conviction against Richard Allen? And if so, does it matter? There have been an interesting development in the Delphi murders case. On March 11th, one of the original defense team filed a motion to reconsider the denial of the motion to correct error, asserting that, hey, there's a new U.S. Supreme Court case that came out that directly impacts this case. The U.S. Supreme Court case came out after the judge in the Delphi case denied the motion to correct errors. So this motion to reconsider the denial is based on this new U.S. Supreme Court case. So let's break it down. One of the key facts is this gentleman named Brad Weber testified that he arrived home in a white van at around 2:30 p.m. There is some evidence suggesting that, in fact, it wasn't 2:30 p.m., it was 2:44, or maybe even as late as 2:50. 14 minutes or 20 minutes, what does it really matter? It turns out it might matter a lot more than one would think, because one of the victim's cell phones stopped moving at 2:32. Richard Allen, in a confession, one of his many confessions, but in one particular confession, stated that he got spooked by a white van, moved the victims across a creek, and that's where the unfortunate demise of the victims occurred. Now, if there's no movement past 2:32, well then, the white van arriving home at 2:30, that supports and puts a pillar of strength on this confession, that Richard Allen actually did it, because, hey, there's an independent incident that corroborates this white van driven by Brad Weber at 2:30, spooks Richard Allen, and he moves the victims across the creek. And now, that 2:32 time is when one of the victims' phone stops moving. So that's what's called a fact not in dispute. That's a solid fact. Now, if the 2:30 arrival time of Brad Weber is not true, well then the confession is not independently corroborated by that event. And so it's maybe less likely to believe, maybe it's not seen as true as, with it, but basically it calls into question that part of the confession. Apparently that was a big part of the closing arguments, big part of the case, that, hey, there was a confession, it was corroborated by Brad Weber, and he's guilty. So we have this. That was part of the motion to correct errors filed by the defense. Now, the state of Indiana said, hey, they knew about that. We never hid that from them. They knew about that back in January 20th, and they could have impeached him on it. They did not. For whatever reason, they didn't make a big deal of it at the trial, and so they can't complain about it now. So the trial judge denies the motion to correct errors right around February 18th. On February 25th, Glossip v. Oklahoma, United States Supreme Court case comes out. And Glossip isn't making new law, it's clarifying this case called NAPU, and basically the state can't put on false testimony, and if somehow false testimony gets out there, the state has a duty to correct it. I'm sure that's not true. The state can't allow false testimony under the due process clause of the federal Constitution. That's what the NAPU case says. Now, the Glossip case just clarifies that, and it says it's not on, the burden isn't on the defense to correct false testimony, it's on the state. Because just like in the Richard Allen case, the defense in Glossip, they knew that Glossip had some issues, that he was on lithium, he's seen a psychiatrist, even though he said he didn't see a psychiatrist. They knew that he might have been bipolar, even though he said he wasn't bipolar. But the court in Glossip clarifies, hey, it's not on the defense to correct false testimony, it's on the state for their state's witnesses. And not doing that is a deprivation of a fair trial under the 14th Amendment. The holding in Glossip is just like NAPU. If the state's witness uses false testimony the state knows to be false, then guess what? The trial was unfair, and under the 14th Amendment, a new trial is necessary. This motion filed by the defense team in the trial court is pretty smart. It's pretty clever. And, it just happened. There's a new case that came out right after the motion to correct error was decided. I think they absolutely had to bring this case in. I don't want anyone watching this being like, oh my God, Richard Allen is going to get a new trial immediately. The defendant in Glossip, the only testimony was by the person who basically kind of told some fibs on the stand. There was no other direct evidence tying Glossip to the crime. So even though the facts in Glossip are kind of the same, the defense should have known or knew of the stuff that was lied about on the stand. In the Richard Allen case, there's lots of evidence pointing that Richard Allen did this, namely confessions by Richard Allen that he did this. So this, in Glossip, the only evidence was of the lying person's testimony. That's not the case in the Delphi case. There's other evidence to implicate Richard Allen in the crime. So I don't know how that is going to affect this case in Glossip. Now, what I love is the lawyers in this case, love them or hate them, are amazingly smart, as is the trial judge. Now, this case is really cool because the motion to, I hate saying case is cool, but this is interesting. The motion to reconsider was filed on March 11th. On March 11th, the notice of appeal was also filed, and the trial judge basically said, hey, listen, y'all filed notice of appeal on March 11th. Therefore, I'm not going to do anything with this because I no longer have jurisdiction. It's with the Court of Appeals. Now, a couple different things. Number one, my understanding of the rules for the Court of Appeals are that trial court has jurisdiction until the clerk's record is complete. The clerk's record was not complete until March 13th. That's number one. Number two, Court of Appeals absolutely hate touching an issue for the first time. They just hate it. That's not how they want to do things. They do not want to have evidence presented at the oral argument, or that's not how they're designed. So by filing the motion to correct error based on new law, what I think is going to happen is the Court of Appeals is going to tell the trial court, hey, you deal with this first and then come back to us. So a couple different things. Court of Appeals could tell the trial court, hey, you got to deal with this. Number two, the defense or even the state theoretically could ask the trial court to assume jurisdiction to handle the motion to correct errors, dealing with the recently decided Glossip case. Or I guess another option would be the Court of Appeals could say, no, we'll take it from here. This is just application of law, not facts. And so it kind of is. Glossip is that. So I don't know what's going to happen with that, but I assume there's going to be some sort of petition for the trial court to reassert jurisdiction so they can at least get a hearing or get a ruling from the trial court. But I mean, it is a legal argument, which the Court of Appeals could simply say, hey, this is an application of law to the facts. But I still think the Court of Appeals would rather the trial court take the first stab at it because that's just kind of their MO, and they don't want to be dealing with issues for the first time on appeal. In fact, if you bring up an issue for the first time on appeal, guess what? It's usually waived. This case just can't stop. It just keeps on giving, and it's crazy. I would love to know what your thoughts are on this, and drop me a comment. Let me know if you agree, disagree, hate me, love me, I don't care. If you watch this long, though, please like and subscribe. I sure would appreciate that. Please don't call me about this case. I don't need any tips. If you have a tip, you want to talk about the case, leave a comment, but do not call. Most importantly, remember to always plead the fifth.